What's going on, guys? It is the Bad Wolf. Blessed holiday seasons to you guys. Each and every one of you guys. Except for the haters, because they're just gonna hate, so we're gonna skip over them. One of the most interesting things for me is always people want to hate, but yet they don't show no work. Now, see, when I was in school, you couldn't just put a problem down. You could say like 10 times 10 is 100, right? Couldn't just put 100. You had to show the work. 10, 10, 0, 0, 0, 1. You have to show the work. So before people, and it's not even just about me. If someone's going to go against you, and I don't care, I don't fall into the whole blue, red, political, blah, 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 gay, straight, whatever. Yeah, there's agendas for all those things, all right? There's some legitimate good behind some of those things, and then there's some legitimate bad and evil and an attempt to take down Rome, if you will, all right, or the United States corporation. Now, I don't think it necessarily should be taken down, but I do think that it should be restructured. I think it should aim more towards Nacera Jacera, okay? But if someone's going to go against you, or the trolls who like to watch mine, whether it's a cop, and they're not all bad, judge, they're not all bad, attorney or lawyer, they're not all bad, secret cabal inside the government working to take down the sovereign and national, they're all bad. And any threat, foreign or domestic. So if you're going to do that, we're here to call you out. Show yourself. Show your work. Evil can't show their work. This goes for males or females out there. Always want to think that they're right, but can't prove anything. They go by feeling. You know what goes by feeling? Kids, animals. They feel, so they believe that they are right. Now, that's also a quote by Aleister Crowley. Do as thy feel, do as thy will. Well, if that was the case, there'd be a whole lot of things on fire, and there'd be a whole lot of people tarred and feathered and worse. And that would be just me starting out on the Sunday or Monday morning. So we can't just do what we feel. We're not right just because we feel we want to do this or that to somebody. That's not how it works. So if you're going to hate, at least show the work. I show the work. Good can show the work. Good and truth can stand the test of time and truth. Here's the work. Here it is. I'm showing you the government's code. So I find it funny when certain government factions, clandestine operations, not the majority of the government, want to look at things and then pay from their little cabal groups and put sovereign citizen movement on the bottom, through your little third party shell corporations, advertising underneath mine. Do you really think that's going to stop all the American people from knowing the truth? Even if I quit today, it's not going to stop the thousands, hundreds of thousands of other people from learning the truth. You're trying to stop Niagara Falls with a branch that's rotted. Just saying. And so to the other trolls out there, same thing to you guys. You guys are nothing but traitors to the United States of America. And we real Americans, we will deal with all threats, foreign and domestic, with extreme prejudice. God bless America. Show your work. If I'm wrong, show your work. Why do I keep winning in court? Why do all of my students who actively train and learn and now are out there doing their own things completely separate from me? Still cool though, because even if we're not agreeing on the same term or code or method, we're not fighting. We're not hating on each other from show to show or YouTube to YouTube or platform. That's entertainment for the Neanderthals, the evil who likes controversy. We can agree to disagree. That's the American way. put our differences aside and work together. So once again, show your work. Toes to toes. Let's see it. Now, without further ado, let's get into it. I'm the Bad Wolf, and your most, I won't say wholesome. Gracious. We'll use gracious. That's a better word. Gracious host, the Bad Wolf, the Man in Black. Let's get into it. So, in this particular video, we are going to be talking about what the is a bill of attainder. Now, this is something that we've used in some of my consultations when dealing with the court in order to, well, be successful. Now, if you guys want to know literally how I move, the methodology, you want to know about 90 to 95% of why I'm successful, how to operate, how, depending on your event, you will always be successful in the courts. But I don't want to say 100% because if you do face somebody who's evil or dirty, ignorant, old, feeble, a double agent, then you're going to have to escalate things. But you will be successful. The problem is these people get to attack us because our government ain't doing a damn thing. We have to then bring that controversy to them. So here's the problem. If I'm dealing with a lower authority that's inferior and not the real law, shouldn't we, the people, like start to wake up and, I don't know, kick out these inferior courts that aren't really American in the first place? Sure, they're adopted into our family, and they married into our family. They've got our name, but they're not our blood. Shouldn't we get rid of anything that's not truly pro-American? These for-profit operating courts, these actors. It's what IMDb has them listed as. These public agents are actors. They're trustees. Sure, they're American people, but they're in a role acting as if they're our family and our friends, and they're really not. They are, but they aren't. So if you're gonna, you know, attack me sometimes, then we're really not family and we're not friends and we're not cool. Oh, it's just business. Now, let's get back to the entertainment, shall we? So, Bill of Attainder. Let's take a look. I got it drawn up here with the old Chat GPT. And as always, guys, if you guys want to know how to move and think as I do, you're going to want to check out my For the Private Citizen National Non-Resident Only. It's not for public consumption. U.S. citizens are prohibited. It's not for you. Go to jamesclovett.com and watch some of those videos. And through the holidays, we have a number of videos on there that are for free. I may or may not keep them for free after the holidays. I may go up, right now you can just make a donation for some. The other ones are paid for streaming. Otherwise, all the other good information about consults and whatever else are on blacksite32.com. Thank you guys in advance for even just visiting. I appreciate you. So, Bill of Attainder. Let's take a look. Hopefully everybody is doing well out there. Whatever you guys are going through, and I know each one of you guys are going through something. I wish you nothing but positive energy to get through it. I believe you can get through it. I believe you can get over it. I feel like you can make the best out of the worst scenarios, situations, or events that you're going through. Even if it's something you can't change, if you can change your mind state, your prison or your hell or your problem doesn't have to defeat you. Only really you can defeat you. You may have to change and you may not like it. But if all you're getting is lemons, learn to make lemonade. Put a splash of vodka in that drink you drank. Kick your feet up, even if you're in hell. Put a couple ice cubes in that bitch. It's up here. Your real war is up here. And don't think I'm immune. I have my own things. Some of you guys now know about certain things in my family that have taken place. things I've gone through with certain females, and even my own girl, the city, the state. I deal with all this on a daily basis. And then on top of my own stuff, I deal with consults almost every day. Well, now I'm on vacation, so I get to relax a little bit. Even though some people still text me and call me and email me. But on a daily basis, that's why you guys pay me to deal with your problems. So if it is something that I can help out with, go to blacksite32.com. Also, keep in mind that we're updating the scheduling system so that once you go, you click one link and then you see all the options that are available, half hour, court, whatever. Um, you will be able to just pick which one you want. That way, it'll log you right into my calendar, and it'll be a lot easier than you having to email me like we were doing in the past because I couldn't find a good system. And also, I don't really have time. I like to get the work done much. I don't really care about the little stuff. That's why you guys will see little mistakes here and there. It's not that I'm just so busy, I don't even care about those little things. All right. So, without further ado, let's get into it. Oh, one more do. One more do. One more. Then we'll get into it. All right. Thank you for all the donations. Thank you for all the shout outs. Thank you for all the people on other platforms that shout me out, and direct people my way. I really appreciate that. It does help. And if you do believe in this knowledge and what I've taught you here and what you've learned on this platform in conjunction with your own or other platforms, whatever it is, thank you. Thank you, thank you, thank you. All right. Is that it? Yeah, I think so. All right, let's get into it.
A bill of attainder is a constitutional separation of powers violation where a legislature, Congress or a state legislature, effectively acts like a court by picking out a person or an identifiable group, declaring them guilty or blameworthy, and imposing punishment, without a judicial trial. The U.S. Constitution bans this twice. Federal, no bill of attainder, shall be passed. U.S. Constant Art. I, Section 9, CL 3. Congress.gov. States, no state shall pass any bill of attainder. U.S. Constant Art. I, Section 10. What it is, the operative definition. The Supreme Court has described a bill of attainder as a law that legislatively determines guilt and inflicts punishment upon an identifiable individual without provision of the protections of a judicial trial. +1. The classic three elements courts look for. Courts typically evaluate three core questions. Specification: does the law target a named person or an easily identifiable group? Punishment: does it impose punishment, traditional punishments like death/banishment/confiscation, or modern equivalents like disqualification, deprivation of rights, penalties? Lack of judicial trial: is the punishment imposed without the protections of a judicial trial, legislature doing the convicting? +1.
Okay. So before we go on, they're telling you, does the law or these courts or a creature of the law look at you as a named person? Oh, that's the bad wolf. I don't like him. Or an easily identifiable group? Oh, those are sovereign citizens. This is targeting. This right here is then a problem of the law. It's a problem. They're using the law in a form called lawfare to go after a specific person or easily identifiable group. So just like I was saying earlier, the group that put sovereign citizen movement, it's either one of the three letter agencies that are clandestine or probably some board group out there working for the state, wealthy party, somebody with pockets. It's one of the two or both. You know who you are. Bothering one person is not blind justice. So for them to bother me, that's already a violation of the law because they don't like what I'm saying. So they don't want it promoted. Why do you think my channel hasn't even reached 100,000 yet? I mean, don't get me wrong, it's still doing good. I've seen people with crappy YouTube channels that have double my numbers because YouTube's also in on it as well, which tells me that it's probably one of the three letter agencies with deep pockets using taxpayer monies to attack my platform. This already fits one of the core requirements that makes them guilty of lawfare. Easily identifiable group. To say either me or all people like me are sovereign citizens or whatever else. I mean, there's even people who go after, Anna von Reitz's group. Not that she's a peach or anything. American State Nationals. Heard it right from a friend who heard it right from an FBI agent. Oh, yeah, we know about those American State Nationals. Domestic terrorists, what we call them. I mean, I don't care if you like what I said or what, it's the truth. Just putting y'all on the radar. That makes them guilty. They're targeting a group. Unless that group is actively doing something as a group to terrorize Americans or the government. And of course, they like to spy on people to see, so they're looking for potentials. But that's where it has to stay. And they're not going to tell you about that. I mean, they look at actors, they look at everybody. Are you a threat? And are you actively gathering people to do things? Are you promoting problems? This is what they do. It's almost like they're starting to run out of bad guys because they've colonized so much of the world underneath their evil banner. They're running out of foreign enemies. So now they're looking for domestic ones. Then they want to impose a punishment. Deprive you of your rights, disqualify you for things. Like for me, denied me my rights, disqualifying me from police usage, putting sovereign citizen movement underneath my, very passive aggressive underneath my videos, and yet they won't tell me who they are because then I can't go after them directly, and it's only it's a possibility, maybe it's them. So they like to hide in the dark, but poke a stick into the light at you. Well, I'm not hiding. Then they don't want to give you anything fair judicially. See, the separation of powers says that the legislative, judicial, and executive all have to operate separately. Well, then why are these courts writing you a ticket and then finding you guilty right away. That's a that's a violation of your rights issue. Due process and a violation of your constitutional rights. On the federal and state side, capital S, state, no state shall pass any bill of attainder. Federal, no bill of attainder shall be passed. Yet these lower inferior courts are doing it every day. So let's look deeper into it so that you guys can know. And once again, if you guys want to know how to use this, see, I give you guys the pieces. My jamesclovett.com website, I give private instruction for educational reasons only. How I know the courts, how I deal with them, the theory of how you should move. So once you get those videos and include the knowledge from here, you guys can be very successful there. You can't take a piece of my video, a piece of other video, and just think you're going to be successful. It took years. I'm giving you guys years of information in hours of videos. You don't need to watch them all. You can definitely shortcut and go right to the jameslovett.com videos. But all these pieces are pieces of you building an appropriate legal style weapon for the legal system. And that weapon is you. The ammo is the knowledge. Knowledge is power. So let's keep going so you guys can get a clearer picture of what this is and then see how it applies to you. Oh, and by the way, if you go to jamesclovett.com or blacksite32.com, you'll see that there's an AI chat script on there for a good low price that will make your chat run like mine. Now, some people have said that the free version, which I have the paid one now, okay, that's how I started off before I got to this one. They said that it works, but you may have to copy and paste it in there again or tell it to use the script. They may be trying to circumvent what I've done, but if you get the copy paste script for the memory, it'll work. Okay? If you want yours to run and give you the results like I get, because they don't teach these AI how to operate in the private. So it will fight you on every single thing until you tell it how to move. All right, so anyway, let's get back to it.
+1. Key point: this doctrine is aimed at legislative punishment, not a judge being unfair. In United States v. Brown, the court emphasized the clause's purpose, preventing legislatures from punishing designated persons or groups. +1. What it is not, important for using it correctly in court. A bill of attainder challenge usually fails if you're attacking a judge's ruling or courtroom conduct. That's not legislation. You're attacking a general law that applies to everyone, even if it hurts you. The government action is executive or judicial, not legislative. So, if your complaint is the judge wouldn't let me speak, that's typically framed as due process/right to be heard/right to present a defense, not a bill of attainder. How to apply it in court: rights assertion use that actually fits. You use bill of attainder when the government is doing something like this. Scenario A statute/ordinance targets a narrow class like people who did X and imposes a penalty. Example patterns: any person who participated in specific protest/event is barred from city employment. Named individuals may not hold office/may not contract with the state. Anyone on a particular list loses a benefit, license, or right automatically. Your argument: the legislative body identified the target, imposed a penalty, and skipped the courts. Scenario B a legislative act effectively declares your guilt by label. If a law is written so that it functionally says members of Group Y are presumptively dangerous/unfit, and it punishes based on that status rather than proving individualized wrongdoing in court, you argue it is a legislative substitute for a criminal conviction, or quasi-criminal punishment.
All right. So this is why you won't see them ever, and I've said that before countless times, even though they keep saying Darrington, 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 and a lot of them don't know. Cops don't know. They're taught this. They think they're right. Most cops always think they're right. Just because they have the might, they think that they're right, and that's not how it works. A private citizen and national have way more power than any cop, judge, lawyer, etc. Period. But you don't know how to move that way. The cops are also not taught to think that way. But they do know that the private citizen is powerful and private. They know that. They talk about it. You won't see it in their books. As somebody who was going to be a cop, read those books, knows these things, you will never see them create a law that says anything about the sovereign citizen. So they'll call you that a little bit, and if they're stupid as fudge, they will write it on your ticket or on your court case or something. They'll call it to you to your face or sleight of hand. They'll mute their mics and say it. They have a whole racket, and they're not all bad, but the bad ones are bad. And how many bad ones do you have if the good ones do nothing? But you won't see them prosecute you as a sovereign citizen. They may call it to you all day because if they wrote it, it would be a bill of attainder.
Punishment. Scenario C. Punishment disguised as regulation. Modern bill of attainder fights often turn on whether the burden is really punitive. The court has considered whether the burden resembles historical punishments, whether it advances non-punitive purposes, and whether it's excessive relative to those purposes. Nixon is a key framework case on that analysis. Just a law plus one. How to present it procedurally, a practical motion structure. If you have a real legislative target, statute/ordinance/special act, you typically raise it as motion to dismiss, if the claim rests on an unconstitutional law, and/or motion for declaratory/injunctive relief, civil rights posture, and/or affirmative defense/constitutional challenge, state procedure varies. Court-ready outline, fill-in template. I issue presented whether, statute/ordinance/act, as applied to, me/us, is an unconstitutional bill of attainder under U.S. Constant Art. I, Section 9, or Section 10, because it targets an identifiable person/group, imposes punishment, and does so without a judicial trial. Congress.gov+1. 2. Governing standard. A bill of attainder is a law that legislatively determines guilt and inflicts punishment upon an identifiable individual without provision of the protections of a judicial trial. +1. 3. Application. Specification. The law targets named person/defined group, because, how ascertainable. Punishment. The law imposes punishment by disqualification, forfeiture, penalty, deprivation, which is punitive in effect and/or resembles traditional punishments. Use Nixon framework. Just a law +1. No judicial trial. The penalty attaches automatically by legislative command, without individualized adjudication meeting judicial trial protections. 4. Relief requested. Declare the law unconstitutional as a bill of attainder and dismiss/bar enforcement. Grant any other proper relief. Your rights angle. The clean way to combine it with due process. If what you're really facing is courtroom suppression, judge won't let me speak, the stronger pairing is due process, procedural notice plus meaningful opportunity to be heard. Right to present a defense/make a record, especially in criminal/quasi-criminal matters. Abuse of discretion, appeal posture. Bias/recusal standards, if supported by facts. Then reserve bill of attainder for when there's an actual legislative punishment device behind what's happening. Interpretive organic layer, your framework, court-safe version. Positive law reading. The Bill of Attainder clauses hard limit government by preventing lawmakers from acting as judge and jury over particular people. Congress.gov+1. Organic/common right framing. It enforces the principle that liberty can't be taken by political condemnation. Punishment must follow lawful adjudication, not legislative targeting, i.e., government must proceed by general law and due process, not person-specific commands. Reality check, so you don't waste ammo. Bill of Attainder arguments are powerful but narrow. They work best when you can point to an actual statute/ordinance/resolution that singles out you, or a tight group, and attaches a penalty, and skips the judiciary. If you tell me what court case type you're in, criminal, family, civil debt, eviction, admin/agency, and what exact law or order is being applied, cite or screenshot, I can format a tight, court-fileable argument that uses 1. Bill of Attainder if it fits, and 2. Due process/right to be heard authorities if it doesn't, so the claim lands in the correct doctrine.
All right. So with that being said, the Bill of Attainder can work if they're going after you personally on some BS. Or if they label you as under a group. You guys are all sovereign citizens. You guys are all those think you know, blah blah blah. Or they personally attack you, skip your rights. Now, this is only one piece. It's not the whole puzzle. So depending on what you are involved in or the event, you may need to use this piece or a different piece, or you can mention this piece in it in your argument. But that's up to you. All right, guys. So hopefully you guys found that information good. Should we take a secondary look? Should we go a little deeper? Let's jump back over and see if we can find any last pieces. Okay, so it just basically said they are powerful, but they're narrow. So this may not be necessarily, you know, it's not a broad sword. It's specific, and they almost never want to let you get this leg up on them, so to speak. So it says here, so you don't want to waste ammo. If it singles you out or a group, they attach a penalty and they skip your judiciary, meaning going to be judged. That's a problem. Now, in one way, like I said, they're very careful. They may say, "Oh, you're a foreign national, you're doing sovereign this or whatever," but they're not going to put it in law. So the legislation, which is not the courts are not the legislative part. So the legislation avoids talking about these things like groups. But some of the dirty police officers and judges who are dirty, not all of them, they they are the ones. So when you make mention that to a judge, hey, you're operating as if this is a bill of attainder here. Let's go on to the next part here. Now we're going into the bill of particulars. All right. Mine, so the way mine is set up is that if it thinks it can find better info, it can take a little bit longer to search for that information. All right, so just give me one more second here. All right. So as you see here, it took 58 seconds, which is what much longer than normal. But I want it to be more thorough.
A bill of particulars is a procedural demand/motion that forces the opposing side to state the particulars, specific details, of a charge, criminal, or a claim/defense, civil in many states, when the pleading is too vague to fairly prepare your response/defense. It is not a bill like legislation. It's a pleading clarification device, used to pin the case down to who/what/when/where/how much/how. What it's for, the lawful function. Criminal, especially. A bill of particulars is used to understand the accusation with enough specificity to prepare a defense, avoid prejudicial surprise at trial, and protect against double jeopardy, so the state can't shift theories later. +1. Federal rule: the court may order it, and the defense typically must move before or within 14 days after arraignment, unless the court allows later. Key doctrine: grant/deny is usually within the trial court's discretion, so you win by showing necessity plus unfairness without it. +1. Civil, state law dependent. In many states, example, New York, a bill of particulars works like written, numbered demands for details of a claim/defense. New York law explicitly allows any party to require it. Justia law +1 New York courts also explain it is not discovery, but can be used to get details about a claim/defense. New York courts. What it is not, so you aim it correctly. A bill of particulars is not a fishing expedition for all evidence, a substitute for full discovery, a tool to demand witness lists or trial strategy. Sometimes courts restrict that. A way to force legal argument. Its core job is facts and itemization. If what you really need is "your complaint is so vague I can't answer," in federal civil you typically use Rule 12(e), motion for a more definite statement, the modern federal equivalent of make it clearer. +1. The three-part test you should build in your motion works across jurisdictions. To maximize the chance a judge grants it, you frame vagueness: the pleading/charge lacks essential facts, who/what/when/where/how. Prejudice: without particulars you cannot reasonably prepare a response/defense, and you risk surprise or shifting theories. Federal courts describe this core function directly. GovInfo +1. Narrow, reasonable requests: you're not demanding evidence, only identifying facts needed to meet the case. That structure tracks the purpose courts recognize. GovInfo +1. What you can demand: examples that actually fit. Criminal, examples of proper particulars. Ask for the specific acts alleged, not just did X. Dates/times, or a narrower range. Locations. Victim/complainant identity if unclear. The means/manner, how the crime was supposedly committed. Which statement/transaction/event is the basis for the count. The theory of liability if multiple are possible from the same generic charge, e.g., which predicate act. Tie each request to your need to prepare a defense and avoid surprise. +1. Civil, especially debt/account cases, common use. Ask for exact contract alleged, attach it, identify signatories. Date of breach, and how breach occurred. Full itemization of amounts claimed, principal, interest, fees. How interest is computed, rate, start date, basis. Chain of ownership/assignment, if applicable. For accounts dated, the statements/invoices and dates sent and how acceptance is claimed. In New York, the statute expressly includes copy of the items of an account.
So why would you want them to be specific in them coming after you? Why not just leave them, let them have their gray area? Okay. When you do this, you're basically saying, I want an itemized list of what you're charging me with, how it applies, where, when, how, what, who. You're forcing them to say that we have all the perfect information on you to take you down. Okay. If they're wrong, it's like them making a pane of glass. If you can find anywhere in there where they messed up, it shatters the glass. I'm not talking about super, super tiny, tiny, whatever. I'm talking about a core piece is fundamentally wrong. Due process, lack of rights, bill of attainder, whatever it is, it shatters the glass. If you don't do this and just bunny hop your little rabbit ass on in there, 99% of you guys are going to make a mistake because you're not doing the right things even before you get in there, which I cover in my jamesclovett.com court case videos and living in the private videos for the private only theory. So, you want them to be as precise as possible. What damage? How much damage? Who totaled that damage? Is that accurate? Is that a verification validation of the damage? What gives them the authority to speak on such a thing? What time did you allege that I got there and did this? Who's seen it? What? What exact code? How does that code apply? If you can ask for this, it makes them work harder and it also shortens their rope because now, if anything's wrong, now, of course, let's be real. The good and bad side of this is that in things that I teach here, yeah, sure, are there going to be some people who are going to misapply it because they just think they can take a piece of my videos and just run in there and do some shit? Yeah. Are there going to be assholes and evil people and mentally delusional people? Seems like there's a lot of that on the internet these days and in the office and whatever else. And do horrible things and then just think, oh, well, this'll get me out of that. No, that's not how it works. Crimes are still crimes. Now, there's a difference between a crime and a statute. Statutory violations, what they like to call quasi criminal or quasi law or whatever, well, those aren't real law. It's not real law. You're generally breaking rules and they consider them to be a tiny piece of a crime. But if you don't have the whole elements of a crime, it's not a crime. So what are they doing? They created a membership where they get to penalize you. Though it all seems like it's the same world, like at Diddy's house, you can go from the backyard barbecue and then walk into the wrong room and seeing somebody getting drilled in their exit only door. You were like, I walked from here to here and I seen it. This is what happened. It's the same thing. But you joined the P. Diddy Playhouse with your birth certificate and your driver's license. And then you were out there driving with that license. That identification, ID, identity document. The letter ID stands for identification document. It's an ID. It's actually a document. So you're telling them you're a member of theirs. You're in that public capacity when identifying yourself with that Document. Documents don't mean just paper. It's something that identifies you in whatever form it takes. So, your credit cards, your driver's license, those are documents. And that's why it is a felony and fraud for a police officer to take your driver's license and run it for no reason, or well, not. Let me back up. Take your passport and then try to say that you are somebody in their database because you're not. Those are two different identification documents. One's for a national, private, federal level. The other one's for state level, public driving privilege. Those are not the same thing. One is for a U.S. citizen, one is for a national. Are those the same things? Do we have both of those? We have both of those, yes. 8 U.S.C. 1401, Cornell Law EDU. Look it up. So we have both, but are they the same thing? No. In other countries, are they? Yes. Here, no. Do cops know that? No. Do most judges know that? Yes. But they can't see the private side because the private side is their boss. They can only see the public side. So they don't deal with it. They don't talk about it. It doesn't really exist. Some federal judges, they're a little bit more open about it. They have dirty little secrets too. I might know a couple of them. So they don't want you to know your real power. They don't want you to know that passport, when done properly, it's not that it makes you above the law. It makes you, it depicts that you have a private side. And once again, I digress. Is there a difference between a U.S. citizen and a national, even though you have both? Seems like you must be all of it. No, they're legally separate. How do we know that? Department of State, 8 FAM 301.1-1, letter B, citizenship versus nationality, states that in other places in the world, citizenship and nationality are the same thing, but in the United States, they are legally different. So how can you have two things that are legally different, but you have both of them? Because one nationality you were born with, U.S. citizenship, you were given that by law as a creation of the legal system by man. One is natural, one is not natural, but you have both. And depending on which side and how you personally move, you could be looked at as having one or the other. But when you were a kid, you only had nationality. Then they ask you to prove residency, residency, res identity. They res your identity. They told you to res your identity. Prove it to us. Prove to us that you're a member of ours. Let's get back in there. The water's fine.
Account. Justia law +1. Deadlines you can cite, examples. Federal criminal, move before or within 14 days after arraignment, unless permitted later. +1. Virginia criminal, example motion generally before a plea is entered and at least 7 days before trial, court of record. Virginia law. New York civil, example response is generally due within 30 days after service of the demand, or objections with reasons. New York courts +1. Remedies if they don't comply, why judges take it seriously. If the court orders particulars and they don't provide them, courts can limit proof, exclude matters not pled, and impose procedural consequences. Example, Virginia District Court form language: the judge may exclude evidence as to matters not described in the bill of particulars. Failure to comply may support judgment consequences. +1. How to apply it to.
So this could be a tactic right here. By asking for the bill of particulars, they then drum up A to Z, what you did, how much it costs, et cetera, blah, blah, blah. Here's all the ones that apply. And then they try to say something outside of what they sent later on. If you don't say anything, the judge may not either, but if the judge catches it, the judge can exclude it. Or you could say, Judge, whoa, 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 this is a violation here. I object. This wasn't in the bill of particulars that they submitted. I asked that it be stricken and removed from the record.
To court when asserting your rights, court-ready approach. Rights framing that stays within accepted doctrine. Criminal, connected to the constitutional right to be informed of the accusation plus fair notice, and practical double jeopardy protection, then anchor it in Rule 7, F. Plus 1. Civil, frame it as procedural due process. You can't meaningfully answer, admit/deny, or raise defenses against a moving target, so the claim must be particularized, or a more definite statement is required. Organic/interpretive layer, court-safe phrasing. This is the certainty/notice principle. The state, or plaintiff, must proceed on definite, knowable allegations, not ambiguity. Ambiguity is the seed of surprise and arbitrary enforcement. In your language, the living man/woman can't be bound by fog, only by clearly stated claims. A tight template you can copy and adapt. Title: Motion for Bill of Particulars, or Demand for Bill of Particulars, depending on your jurisdiction. Identify the pleading/charge you're targeting, complaint/count/indictment paragraph numbers. State the deficiency. The allegations are so vague/ambiguous that I cannot reasonably prepare my defense/my responsive pleading. Plus 1. State the prejudice, risk of surprise and inability to prepare. GovInfo plus 1. List numbered requested particulars. 10 to 20 targeted items is usually better than 80. Request relief. Order the opposing party to serve a bill of particulars by a date certain, and any appropriate limitation/exclusion for noncompliance.
All right. Now I'm asking it if there are any other bills of anything that I can use or should use when asserting my rights. It's going to take a little while, guys. So just, all right.
Yes, there are several bill of underscore 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 terms that show up in court practice and can matter when you're asserting rights.
Let's go.
The key is using the right bill for the right procedural moment, pleading clarity, record preservation, post-judgment relief, etc. Constitutional bill concepts, rights limiting government power. 1. Bill of Rights. Not a motion, but the first 10 amendments, your primary rights backbone, speech, due process, jury, confrontation, etc. Plus 1. 2. Bill of Attainder and Bill of Pains and Penalties. You already have the Attainder piece. The related term is Bill of Pains and Penalties, a legislative act imposing a lesser punishment than death on a targeted person/group without a trial. Same constitutional problem, different severity label. Plus 1. Court procedure bills you can actually file/use. 3. Bill of Exceptions. A formal device to preserve error for appeal, especially where something important isn't otherwise captured in the record, e.g., excluded evidence, an off-record ruling. Some states still use this concept explicitly in appellate rules. Plus 1 rights value protects your ability to get meaningful appellate review by ensuring the record reflects what happened. 4. Bill of Review, state-specific, equity/post-judgment. An independent equitable action to set aside a final judgment after ordinary deadlines, new trial/appeal, have passed, classic in some states. Texas is the modern hotspot. Plus 1 federal cousin, Rule 60 relief from judgment, and related independent action concepts. Rights value gives a path to challenge a final judgment when fraud/mistakes/other narrow grounds blocked a fair hearing. 5. Bill of Costs. A post-judgment itemized request for taxable costs, and/or your objection to the other side's claimed costs. In federal court, costs are presumptively allowed to the prevailing party unless the court orders otherwise. Plus 1 rights value protects you from getting hit with improper costs and lets you contest or narrow them. 6. True bill of indictment. A grand jury's decision to indict, true bill, versus refusal, no bill. Plus 1 rights value helps you understand how the prosecution commenced and what must be proved procedurally. 7. Information/bill of information, charging document. An information is a prosecutor-filed formal accusation that can initiate criminal proceedings, similar role to an indictment, depending on jurisdiction. Plus 1 some states use the phrase bill of information in their codes. Louisiana, for example, defines information as a written accusation made and signed by the prosecutor. Rights value anchors notice, you can attack vagueness and demand essential facts in the charging instrument. 8. Pure bill of discovery, rare/limited, jurisdiction-specific. A standalone equitable action seeking discovery only, recognized historically and still discussed, notably Florida, but courts often treat it as disfavored/limited under modern procedure. Plus 1 rights value can be used, where allowed, to force disclosure needed to frame a claim/defense when ordinary discovery isn't yet available. 9. Bill of interpleader. An equitable action where a stakeholder holding property/money forces competing claimants to litigate between themselves, so you don't get whipsawed. Plus 1 rights value protects you from multiple inconsistent liabilities and centralizes the dispute. How to use these bills as rights tools, the practical map. Pleadings are vague? Bill of Particulars, criminal/more definite statement, federal civil, Rule 12(e), the Florida bar. Judge blocks evidence/off-record rulings? Bill of Exceptions/proffer/make a record plus 1. Judgment entered and you need cleanup/reversal? Bill of Review, state/Rule 60, federal, plus 1. They try to saddle you with money after judgment? Bill of Costs/oppose taxation of costs. Multiple parties claim the same money/property from you? Interpleader. Criminal case started by indictment/information? True bill/information analysis plus 1.
There it is, guys. Jam-packed as always, because you know who it is. The Bad Wolf. Got your back. Now, Go out there, be non-belligerents, non-combatants, stay out of trouble. Catch you guys later. You know what to do. Hit them lights on the way out.